Thanks very much for coming to City Club today. You can continue eating, that's fine. I'm Tom Benson with the Missoula Cultural Council, and I want to thank once again A Squared Catering for being so accommodating with City Club. They've done a great job. And speaking of lunches, one of the things that A Squared Catering is doing to be so accommodating is they're not charging us to rent this room, but obviously they are charging us for the food. And the food costs $10, and we've been charging $10. Now, anybody with any business sense knows that that's probably not the right thing to do. So what we've decided to do, the steering committee met this past month, and we decided that starting in March, that lunches will cost $13, and the no lunch option will remain the same at $5. Now, the flip side of that is we also had a long, lengthy discussion about membership of City Club. And after trying to figure out how we would organize and create a database and what the fee should be and what living lightly would be, it finally came out that let's just not have members. Or let's all be members of City Club Missoula. And so we will not have individual memberships, but we will still be soliciting businesses for sponsorships and individuals for donations, but we will not have an individual membership plan as we had decided. We also now officially have an email address, which is, you see the yellow card is on the table, cityclubmissoula@aol.com. Thanks to Jim and Dorothy Crocker for setting that up. And we have also begun the organization process. David Bjornson has donated his time as a lawyer to file the bylaws and the articles of incorporation with the state. So we're moving along in the organizational end of things. And one last thing is that next month, the meeting will be the third Friday, March 18th, and it will the topic will be the city and county government study commissions that were elected last fall. They will give a presentation. We'll have a discussion that way. The format that we have set out for City Club for the past several weeks is kind of what we're going to be doing for the next year or so, sending out invitations, notices, and asking you to RSVP. We will probably be here for a while. A Squared has done a great job of, as I said, accommodating us. And we'll have the speaker or speakers talk for about 20 minutes, and then we'll have table discussions, and then at the end, we'll come back and each table will report, and we'll do that today after we're done. And now Barb Kustra from the steering committee and also from the Museum of Art and Culture will introduce our speaker. Barb?
Thanks, Tom, and thanks everyone for being here at City Club Missoula. I have the real pleasure of introducing our speaker today, Dr. Paul Miller, who has taught sociology at the University of Montana for 35 years. He holds a BA from Montana State U, an MA from the University of Texas at Austin, and a PhD from the State University of New York in Buffalo. He also received a postdoctoral fellowship from the University of Minnesota. Before coming to Missoula, he taught at the San Francisco Seminary, at the San Francisco State University, and other universities. He received in 2001 the Kenneth Wilkinson Rural Policy Award from the Rural Policy Interest Group of the Rural Sociological Society, and that is quite a lot of syllables in terms of an honor. His research during his scholarly career has focused on a myriad of topics, including social welfare policy and reform, the costs of raising children, student behavior issues, including bullying and high school violence, at-risk students in Missoula's public schools, quality jobs, hunger and poverty issues, the social impact of mining in Butte, and many other topics. And a lot of his recent research relates directly to what he'll speak of today, the challenges in implementing federal faith-based initiatives here in Missoula. He grew up in Kansas and received an athletic scholarship to the University of Montana, so he's an ex-jock. And he and his wife, Peggy, have 3 children and 2 granddaughters. Now, Paul plans to retire after the now spring semester. And in the fall, he's going to take off for Massey University in Palmerston North, New Zealand, which is a sister city to the University of Montana. And of course, Palmerston North is a sister city to us here in Missoula. And just for your information, we'll have a guest speaker from Palmerston North, New Zealand here with us for City Club in June. Should be a very fascinating day. That's June 24th. We really appreciate Paul taking the time and, of course, the preparation to be with us today at City Club, and I give you Dr. Paul Miller.
Thank you very much. I'm going to try to talk without the microphone. Can you hear me? Just give me a high sign if you can't hear me. Today I want to thank Barb for a very generous introduction, and actually I'm honored to be introduced by Barb because I was a good friend of her father, Walt, and Walt made a lasting contribution to the lives of many of us through his living example that it was okay for a grown man to listen to the people he votes. And talk about it publicly. So I thank Walt for that. I'll think about that. I want to talk about a phenomenon known as faith-based initiatives. If you don't know a lot about the faith-based initiatives, don't be too hard on yourself, because the public policy called the faith-based initiative sort of sneaked up on us in 1996 without a public debate. It is being debated and discussed in many varied ways now that I'll talk to you about today. We do get a few indicators of this phenomenon. January 3, Missoulian had a piece on the U.S. gave $1 billion to faith-based groups in 2003. In January 4, they followed up with a statement about the federal administration wanting states to be more proactive in providing support for faith-based groups. And I want to say a cautionary note at the beginning. It's easy to take the position that the faith-based initiatives are a phenomenon solely of the Christian right or the religious right. That is not the case. We don't have time here today to go through the years of discussion and policy making that has led up to what we call the faith-based initiatives. But there are, you may remember that Al Gore and Joseph Lieberman ran supporting faith-based initiatives, gave talks supporting it. In the last election, John Kerry gave a major address to 3,000 ministers supporting the faith-based initiatives, and actually came out with some recommendations that are very similar to what President Bush is having right now. And the busyness of this public policy initiative is so high right now that there is an active set of groups meeting to try to do something about it. One of them includes Senator Santorum from Pennsylvania and Senator Clinton from New York. Also includes Senator Lieberman, and incorporates a former senator from Pennsylvania, Harris Wofford, who was sort of the arch enemy of Rick Santorum in their elections. And closer to home, our own former Governor Mark Roscoe is working with Dan Glickman, former Secretary of Agriculture, trying to develop a new entity called the U.S. Consensus Council for the purpose of addressing issues such as those related to things I'll be talking about today that are contentious, to see if it's possible to find out where there are some mutually agreeable grounds, and then where they agree to disagree, hopefully honorably and without violence to each other. So The faith-based initiative as a present public policy was kind of sneaked up on us, as I indicated, as part of the Welfare Reform Act of 1996. Most of our discussion on that act had to do with the elimination of the entitlement program called Aid to Families with Dependent Children, the limits on lifetime access of certain public policies, the emphasis on requiring work and work-related activities for the poor who receive these benefits. President Clinton vetoed this bill twice, and in the process, the bill became a Reconciliation Act, a conference committee. During the reconciliation process, Senator Ashcroft, then Senator Ashcroft, inserted Section 104 into the Senate side of the bill. It was sunk at the bottom of a huge bill that was about that thick. Nobody knew that it was in there. You won't find any newspaper accounts debating what became known as the Charitable Choice Clause, Section 104. I've been doing some work with Representative Chet Edwards from Texas. He was on the House side, and he thought maybe only about 11 members of the House of Representatives knew this particular Section 104 was in there. Section 104 was slated to be voted out of the bill by the Senate on what was called the Byrd Rule that was invoked by Senator Packwood. But one day before the Byrd bill was supposed to be voted on this thing, Senator Packwood resigned from the Senate. And as under Senate rules, there could not be a substitute, and so this Section 104 was sort of inadvertently in some ways included into the act. But it became the basis for the faith-based initiative, and I'm sorry, you probably can't read it very well, but the act says to allow states to contract with religious organizations or to allow religious organizations to accept certificates, vouchers, and other forms of disbursement on the same basis as any other non-governmental provider without impairing the religious character of such organizations and without diminishing the religious freedom of the beneficiaries of the assistance. That is a loaded statement that has all kinds of issues that we'll need to discuss, and what I'm going to do today is show you a little bit about how this bill, how the policy is shaking out, and then I'll focus in on the issues that Missoulians would need to be thinking about as they address this particular issue. So we'll be coming back to some of these the language in some of this. As you can see, the privatization movement is inherent in religious organizations' ability to accept certificates, vouchers, and those kind of things. So we'll be coming back, and I'll keep an eye on the time here if I can. When the bill was passed in 1996, the Welfare Reform Act, most of the attention of the nation was focused on the effects of the elimination of the entitlement program called AFDC, and we in Montana were perseverating on how many people were taken off the rolls and those kind of things, and what was going to happen with child support payments and what have you. Not much was done with the faith-based initiative. However, President Bush was involved in faith-based kinds of initiative work in Texas. He's a very close friend of a professor at the University of Texas named Marvin Olasky, who had written a book called The Tragedy of American Compassion, and that's the basis for the Compassion Capital Fund and Compassionate Conservative and those kind of things. President Bush had his own personal transformation, as you know, religiously, and so he uses that kind of a language more in terms of the personal transformation of the faith-based initiative, not so much the public policy, other aspects of it. But he was very serious about it, and so the first act, one of the first acts in his presidency, was to establish the White House Office of Faith-Based and Community Initiative. Acronym is FBCI. If you click on White House FBCI, you'll get their webpage, and you will see a statement of purpose and rules and regulations and what have you. This is much bigger than most of us thought was going to occur, because you'll notice each one of these departments that I list here also has an Office of Faith-Based and Community Initiative in it. Each one has a web page a list of projects that faith-based groups can participate in. And each one of these departments has workshops and other kinds of public gatherings to help you, if you're a faith-based group, engage in competitions for grants. It's a very serious business. We haven't heard as much about it in this part of the country. We're not as active in it. We're the least active part of the United States in this. There are other parts of the United States that are quite active, very competitive. Some of them have very large-scale projects going on. Anyway, you can see that this would also include the possibility of international kinds of work with faith-based groups being involved. So the issues I'm going to talk about, you can see, are shaking out in various ways here that we haven't really, don't understand how all this is going to go. Some of the states are pretty aggressive with respect to the faith-based initiatives. These are the states, including the District of Columbia, that have established their own offices, and they're usually in their governor's office or in an office of community development of some kind, faith-based office. I forgot to tell you this, I've been working with a group called the Rockefeller Institute, which is a think tank in the East. It's supported by the Pew Charitable Trust. We're supposed to be nonpartisan and non-sectarian, so I try not to misspeak myself here today. But whenever we have a conference, people from these states show up, they take notes, they watch very closely because for various reasons, they're strong competitors in the monies that might be available for faith-based initiatives. They tend to be states, in some cases, that have very aggressive church groups, Black Methodist, Black Baptist, Central City groups that started in the 60s with the Industrial Areas Foundation, sort of faith-based kind of economic development. They watch this stuff very closely, and they're very competitive. And you can see there's a state that starts with M up there that isn't on the list. So I have done a study of people from our state. We won't have time to talk about that today. I wanted to just look at kind of a model here. I'm sorry, you probably can't read that very well. A model of what the faith-based initiatives present us with in terms of some challenges, and talk just briefly about changes that have occurred, particularly with respect to the role of the courts. One of the things I want to make sure I talk about today is the importance of the state constitutions, because those are going to be critical in the minds of many of the scholars, particularly legal scholars, studying this faith-based initiative. And Montana has the most restrictive state constitution of all 50 states with respect to church-state relations, and also prohibitions against direct and indirect funding. So don't let me get out of here without talking about that a little bit. But what we have here is a question of public funds can be used by faith-based organizations, or what the Supreme Court historically called pervasively sectarian organizations, for the purpose of delivering public service without engaging in inherently religious activities. I wish I could give you an ironclad definition of what those things, how they are defined. We have had some of the funniest exchanges in my life amongst researchers, but also with faith-based people and the presidents trying to define what a faith-based organization is. And I don't want to misspeak myself, so I'm not going to tell you, but it's pretty funny when you get analogies to somebody's baptismal procedures or something like that. Up until, from the World War II up until the 1980s, the U.S. Supreme Court tended to be pretty strict in their interpretation of separation of church and state. In other words, they used the first clause of the First Amendment, the Establishment Clause, rather strictly. And of course, they were always interested in the freedom of exercise or freedom of religious participation clause, but they used a rather strict definition, and they often used the term pervasively sectarian organization to organize or to speak to the separation of church and state. However, in 1980, the court began to change its definitions in the cases that it responded to, and began to argue that faith-based organizations could deliver social services if they were secular in nature and were viable as a result of legislative bodies or legitimate administrative kinds of activities. But the idea was that in the delivery of the social service, you could not engage in what was called inherently religious activity without having a strict definition of what that is. So from, say, the 80s on, the court looked very favorably upon Lutheran Social Services, Catholic Charities, Jewish Federation, Salvation Army, getting substantial amounts of public monies and delivering a social service. And again, as long as they did not engage in inherently religious activity, usually which meant proselyting or some kind of ritual, religious ritual or of that nature. However, since about 2000, the court has been loosening up what constitutes an inherently religious activity. The result has been a lot of confusion out in the field, including confusion here in Montana, where our one faith-based project was recently found to be unconstitutional and was moved off the campus of the MSU Bozeman. I'll talk about that a little bit. But on the court, Justice O'Connor and Breyer are kind of swing voters, and they have been willing to permit faith-based organizations to deliver a service with a little bit of a tinge of inherently religious activity, as long as there is a choice involved. In other words, some would say a choice whether you don't want to do that part of the delivery of the service, or whether there is the choice in the community of another organization that can deliver the same kind of service. O'Connor has been a swing vote, and in cases where there was no choice, she came down as the projects were unconstitutional. Where there was a choice, she has come down on the side of that it is constitutional if there is, in fact, a choice involved. This, of course, drives people who believe in the separation of church and state absolutely apoplectic because it's an abrogation of the separation of church and state as they see it, because it's just a little incremental move, into the fact that we will be publicly supporting parochial schools someday, through vouchers and other kinds of activities that will definitely be inherently religious activities. And there have been some recent court decisions also with respect to the AmeriCorps program and others that indicate the court has really confused itself over how it's going to move on these issues. I'm sorry I'm talking so fast, and I hope you can keep up a little bit here. Let me look at some of the basic issues that we would have to be concerned about here in Missoula. And some of you I know you're affected by this because you're competing with faith-based organizations, and in the way that some organizations give points to contests for grants, they'll get extra points if they're a faith-based organization. And if you're not one, you just lost out on some points. And of course, there are those that'll say that's privileging faith-based organizations, and there are court cases to indicate that the court feels that way too. In fact, the federal magistrate in Montana said that MSU was privileging faith-based groups and moved a project off their campus recently. Let's look at the idea of a level playing field. The original idea behind faith-based groups participating was in the competition was that they should be able to apply for grants on the same basis as any other essentially nonprofit association. That was the general idea, nonprofit association. So in a sense, if you were a county or a city administrator of some kind, or you had a federal project that was you were passing funds through, you would seek proposals from competitors, and you would treat the faith-based competitor equally, or a level playing field. What's happening now, however, is the criticism that the playing field under Bush administration and expectations, if you read the web pages of these groups, is that the level playing field isn't level. In fact, it's being tilted in favor of the faith-based groups, which means your large-scale and normal nonprofit competitors for grants are screaming foul because they feel that they aren't graded out quite as highly because of the faith-based, the points that might go to a faith-based. I might just say a few words about what happened in Montana, because I know some of you, I think, may have grants from them right now in the one project. It's the second one here. It's the Freedom from Religion Foundation from out of Madison, Wisconsin, sued the Montana Faith Health Demonstration Project at MSU Bozeman. That was funded by money from the Compassion Capital Fund of President Bush's money. And, when the money came down to MSU, the fellow that administered it and had the grant was a devout Christian and was, well, as the court found, privileging faith-based groups in the process. And so a federal magistrate, they asked for a summary judgment of the district court, and the magistrate said that the project had to get off campus and this fellow had to be removed from the project. But I know some in Missoula had funds from this grant because it was capacity building was the purpose of the grant. The court said nothing about your projects. It just said that it was administered in a way that privileged faith-based groups in competition with others. I kind of thought this was going to happen because as part of my research I was studying that group and I knew there was something was going to happen. It was very clear. I might just say a few words about Locke v. Davie because it has profound effects upon Montana, and then we'll quit here and let you guys discuss. Gary Locke is Gary Locke, of the former governor of Washington. Joshua Davie was a student in Washington, a very bright student who won a scholarship to the college of his choice in the state of Washington. He chose a fundamentalist college that was accredited college, but had to sign an oath when he entered the college that the Bible would be the ultimate authority on all issues. And then when he got on campus, he decided to major in business and the ministry. The state of Washington took his scholarship away because they have a clause like we do in Montana. It's called the Baby Blaine Amendment, but it's a clause that says you cannot fund direct religious education. And his lawyers and what have you sued in the federal district court, and the district court found in favor of the state of Washington that in fact he was engaging in an inherently religious activity by preparing himself for the ministry. The Ninth Circuit Court in San Francisco voted in favor of Davie, saying that his free exercise constitutional right had been abrogated by state of Washington, and so they found in favor of Davie. Well, of course, it went up to the Supreme Court, and the court ruled with Justice Rehnquist, the Chief Justice, writing the opinion that in favor of Locke, or in favor of the state of Washington, arguing that a states' rights approach, that states have the right to determine what auspices they want to give money. If they have a constitution that precludes giving of money for religious purposes, they have a right to do that. What that means for us in Montana, and then I'll close here if I can find the overhead. Some of the persons I'm working with on my project with the Rockefeller Institute are legal scholars, and they're paid rather well, I think, to do this kind of work. The rest of us are peons. But, oh well. These are state constitutional provisions, and I think one of the questions on your green sheet was, is Montana going to have to change its constitution if it's going to ever be competitive in these kinds of things? And these Lupu and forget the other guy's name. They think that Montana probably would have to have almost a constitutional convention. These are the 50 states that have various clauses in their state constitutions following Rehnquist's decision that state constitutional provisions should hold, maybe and shouldn't be trumped by federal constitution in certain ways. 10 states have non-establishment clauses in their constitution. We have that. 37 states have no funding for religious organization clauses in their constitution. We have that. We call ours the Baby Blaine Amendment because it's named after James G. Blaine, Attorney General of the United States at the turn of the century. 29 states have specific clauses with no funding for education, and of course part of the privatization movement in America is to try to use vouchers and other certificates to fund education where you'd have parochial or public, but you'd have a choice in the community, and this is where kind of wondering what's going to happen here. And then 10 states have no funding clauses that prohibit direct and indirect, so there goes your voucher certificate, but it also prohibits direct funding. And Montana is the only state of the 50 that has all 4 provisions in its constitution. So talking with the legal scholars, they're looking at the 14th Amendment to the Equal Protection of the Laws Clause, saying, I don't think Montana is going to have a fair shake at these monies, given our state constitution. And kid you not, there are adversarial groups all over the place ready to sue on every aspect of this to force the courts to come to some decision. I'm afraid I've overtalked my welcome here already, so this is a long-winded project if you're not careful. So I apologize for talking so much.
So we now have about 10 or 15 minutes to discuss among the tables. I'll turn the lights on here in a sec.
Oh, okay.
And if your table is kind of thin, you can move to another table where there's a discussion, and then what we'll do is we'll go around at the end, as we've done in the past, and have each table report on what they discussed. I think you have some possible issues on the green sheets at each table. Thank you again, Paul. But why don't we start with this table here, if Fern has a report?
This was much too interesting, and I'm not as efficient as Paul. I think, all right, we stayed quite a while on number 1, relating to what are the pros and cons of engaging engaging in public education and direct action to change the Constitution. It's very difficult to change the Constitution, and so you ask what are the pros and cons. One of the cons is that you might change the Constitution, and this may be a phenomenon of a smaller length of time, and then we decided it's very hard to kill things that have become a part of national or local government. The con is, and I thought this was a good perception, this is one pie. What it does is change the amount of folks that can ask for a slice of that pie. Missoula has probably more nonprofits than any place in Montana, surely, and maybe even other states. Should Montana promote these partnerships with individual congregations or a group like Lutheran Services? Probably you could do better regulatory fairness organization-wise if you dealt with a larger group. The relative gains and losses presented to Missoula by faith-based initiatives, I think we almost covered that. We've got many, many nonprofits in Missoula, and so this makes it much more highly competitive. And if it is the case, which many believe, that you get more points if you're faith-based, that's unfair. Okay. Have it.
Okay. At this table,
we sort of didn't look at the green sheet, but we had enough of a conversation among us anyway. We started off reflecting on historically how important faith-based social services have been well before the federal government was involved, way back when, around women's suffrage time, and affirming the history of that. Pat brought up some concerns about excessive tanglement in the churches, and churches themselves are concerned about this as well, that it's a problem not just for the government side, but it may be a problem for the church side if it invites excessive entanglement of the government in the life of the church. So that was one point that was raised. There are some churches I know who are also concerned, not just on the entanglement side, but, oh, now I lost this point completely. Maybe I'll remember. Daniel raised the question about a legal question. Paul, was this one of your points, that there may be advocacy groups prepared to bring suit against the Montana state constitution, other national groups or even Montana groups that are prepared to do that so that there will be more access to the funding? Is that what you were saying?
I'm not sure that any group that would go litigation right now to increase the access. Most of the litigation is coming from those who want a wall of separation between church and state. They're very active at the present time, and they're the most energized, I think, at the present time. But I think there would be those eventually who would like to see constitutions changed in a way to open it up. That is the position taken by President Bush and Jim Toohey from the White House here in the last few days, is that the states are going to be pressured to figure out ways to allow a greater participation of faith-based without having to have a set-aside fee for going to court as part of their...
Okay, great. What am I forgetting? Oh, was I? Oh, Pat had brought up some concern that that this access to funding might cause a growth in new churches who come into being just for getting funding. I think he's a little cynical there, but maybe not. We'll have to see.
Thank you. At this table?
We too went way off that green sheet. But in light of the church in every corner, one of our discussions was about accountability for the funds. I've been part of nonprofits that the accountability was so stringent when you get federal funding, it's not worth getting it. But people at this table had done reading that said there's little accountability on the part of the faith-based organizations receiving this kind of money. I don't know about that. Our main thought, or maybe it's just mine, is we have a lot of nonprofits in Missoula and actually across the nation. They have the structure, they have the knowledge, they have the skills. Why aren't we funding them adequately? Why do churches have to step in? Did we talk about something else? I get that was good.
Thank you. Russ.
The discussion went in quite a few directions. I think to give you kind of the culmination, one of the things that at least I feel is that we probably don't know enough about this and what all the implications are and the intricacies. And there's a lot of nonprofits in Missoula. How is this going to affect them? A couple other things we were talking about is that in city halls, in Christmas time used to have a nativity out in front. Now there are lawsuits to keep those nativities from being there. But on the other hand, you know, you've got this faith-based effort here. You've got Target stores saying that Salvation Army can't be out in front with their buckets at Christmas. So, I mean, the real concern here is what type of division is happening in the country. You're getting, as she said, you know, you've got Bible thumpers on this side, you got Bible burners on this side. What's going to happen with? I think it's more that those that just read them on Sundays, but. You know, what is this leading to? Where is this going? And I think, if anything, more study, more understanding about the whole process is something that I think we know, especially with all the nonprofits in Missoula and the surrounding area. You know, does Kiwanis qualify as faith-based because they have a prayer before they eat breakfast? You know, where does it stop?
They would be known
Jim, we have a jump ball here. I'll pass it on to another table. Maybe you guys will want to come back.
We're a shameful group who came in late, so we only got to talking to number one, and it was a strong consensus that we do not want to tamper with Montana's wonderful Constitution.
And this table.
Oh, geez, we have notes that everybody wrote. Under the first one, what we really were talking to Paul about when he came over to our table was, how much money are we talking about? Was it just the billion, that had directly gone to the faith-based initiative, or was it lots and lots more? And it turns out it was lots and lots more, that it is every one of those departments up there that has money that is granted to states and directly to organizations that affects it. So we needed that to frame the question about the Constitution. I think we were concerned about the notion of an entire constitutional convention, because then everything in the entire Constitution is up for grabs. And as we know, it barely passed in the early 70s as it was, and as it is now would probably not pass in Montana because of certain aspects that are unique to the Montana Constitution. So talking about initiative process and the concern about the ripple effect of that you have to give something like this a great deal of thought. Other things we're talking about, is there a means of circumventing these rules without going through the Constitution by developing collaborations, which, there's lots of this going on. Can a nonprofit partner with a faith-based organization get those much needed points and still use the expertise and experience of the nonprofit that has been offering these services well for years? Because right now there seems to be no points advantage for these nonprofits that have done this work very well for years, and this new interloper can come in with their points and get the money, and yet the fact that it's been offered very well, and we also talked to agree about the accountability, and I can't read my people's writing, and that would appear to be about if we stand for separation of church and state. Oh yeah, okay, we're kind of strong in that area at this table, so we're done.
I would have to say that we probably echoed quite a few of the same sentiments that have been expressed here from the other tables. So I think the few things that I might point out, and we did jump around in the discussion, but a couple of things that came up that were maybe a little different is we wanted a further discussion of what is a faith-based, how do you define faith-based? We had groups prior to the faith-based initiative that were functioning quite well without any need to have, he's going to pull out his hand out. But I think you said, Paul, it was kind of still vague enough to, Great.
This is Paul's definition.
Okay. Right. So that was kind of the question, because we, Salvation Army and Habitat for Humanity, there are quite a few groups that were doing this work prior to the faith-based initiative, and so, why are we now promoting something that was working fairly well without this extra boost from the federal government? And I think the other comment from a member was just that, well, and those are faith-based institutions, and, by supporting the Salvation Army, you really are bringing in religious ideology into social services, and then you don't have separation between your church and state. Am I saying that the way it was expressed? Not quite. But anyway, just that there already was a complicit agreement, but that we're supporting those groups and they're religious, and so there's some sort of promotion of religion through government funding.
Ask a question.
There is a very clear wall between the Salvation Army religious side and services side. Very clear. There's no proselytizing. They aren't even in the same location. So there's a very clear separation there. It's my understanding that Salvation Army here, at least, does not qualify for faith-based money. They have applied for, or they were told that they are not eligible for any funds from that.
I haven't studied them, so
Did this table over here want a second shot? Okay, Mike.
So, Paul, I just had a question with your definition. So is religious philosophy also defined somewhere? I mean, an atheist, organization is a religious philosophy. A Democratic Party is a religious philosophy, if you want to, take a broad sweep at it. And so is that also defined? Do you have to somehow declare yourself as a religious organization?
I would say religious philosophy is not defined by any of the government bureaus at the federal level. They use some kind of criteria like this to designate a faith-based designation, which has a spiritual or theological or some other kind of grounding. Quite frankly, those that push the faith-based initiative hard are Christians. And some of the Christian, you probably know that the mainline Protestant denominations have not supported the faith-based initiatives. They don't support it. They work against it.
Because of the
separation of church and state issue primarily. The leading challenger in Washington is from a group called Separation of Church and State. Happens to be a Congregationalist minister, Gary Lynn is his name. But when an Islamic group in Baltimore got faith-based monies to provide safety in a public housing project, a number of TV evangelical groups and programs that are significantly powerful and had lots of money pulled out their support. So, I'm trying to be sectarian. Presenting the facts. And the conferences that I attend where we discuss our research leads me to indicate that Muslim Americans feel left out and threatened by this. Research projects on cooperative ventures between Christians and Muslims that are faith-based kinds of projects have not been very successful because, again, ideology and religion underlies their activities to some extent. In the case of outside of Athens, Mississippi, there's an extensive Muslim community. They were working with the Baptist group, and inadvertently, or maybe not, the Baptist group had a fundraiser that included what they called the March for Jesus. Well, that didn't set well with enough Muslim participants. And there you go. So your question is a good one. We're a highly sectarian nation. Missoula itself has, in the last census, it has, how many did I say, 86 or 84 different identifiable religious different entities. They might not be, you might look at them from a distance and say there's not much difference, but for those that are the members of those things, those make a lot of difference. So I want to remind you one thing, then I'll shut up. You've been talking about how many nonprofits we have in Missoula, but remember, the Bush administration poses the possibility that anybody can apply for the grant. They don't have to be a 501c3, and they don't have to be one of your tried and true, experienced, historically responsible 501c3s. You have to, that's why I kind of one of those questions I didn't get it set up right, because that means if you're part of a pass-through public funds, you may receive a request from a highly sectarian evangelical group. And you better be prepared to have some criteria in place over what you're going to do. Because you may be hit pretty hard by somebody else saying you have discriminated on the basis of the level playing.
Before we go on, this discussion clearly is not going to stop, and it doesn't have to, but it is 1 o'clock, and if people feel the need to leave, they have to go back to work anytime. But next month, it's March 18th. It's the City and County Commission study group. I don't have the long list of what but they're going to be here next month. Thank you again for coming, and let's continue to talk. And thank you very much, Paul. What a wonderful discussion topic.